since health and safety representatives are to ensure that they look into any incidents and accidents that have occurred within their area of responsibility within a company, it is good to know what incidents and accidents must be reported to the Department of Labor. We will discuss this now in Section 24 of the OHS Act, Report to Inspectors regarding certain incidents. Each incident occurring at work or arising out of or in connection with the activities of persons at work or in connection with the use of plant or machinery in which or in consequence of which any person dies, becomes unconscious, suffers the loss of a limb or part of a limb, or is otherwise injured or becomes ill to such a degree that he is likely either to die or suffer a permanent physical defect, or likely to be unable for a period of at least 14 days either to work or to continue with the activity for which he was employed or is usually employed, a major incident occurred, or the health or safety of any person was endangered, and where a dangerous substance was spilled, the uncontrolled release of any substance under pressure took place, machinery or any part thereof fractured or failed, resulting in flying, falling, or uncontrolled moving objects, or machinery ran out of control, shall within the prescribed period and in the prescribed manner be reported to an inspector by the employer or the user of the plant or machinery concerned, as the case may be. In the event of an incident in which a person died or was injured to such an extent that he is likely to die or suffer the loss of a limb or part of a limb, no person shall without the consent of an inspector disturb the site at which the incident occurred or remove any article or substance involved in the incident therefrom, provided that such action may be taken as is necessary to prevent a further incident, to remove the injured or dead, or to rescue persons from danger. The provisions of subsection 1 and 2 shall not apply in respect of a traffic accident on a public road, an incident occurring in a private household, provided the householder forthwith reports the incident to the South African Police, or any incident which is to be investigated under Section 12 of the Aviation Act of 1962. A member of the South African Police to whom an incident was reported in terms of subsection 3b shall forthwith notify an inspector thereof. When incidents or accidents happen, there are a few things that must be done. Two of these things are recording or recording and reporting. Recording. Any incident, regardless of its severity, should be recorded and kept as records for incident and accident management. This is a great tool to identify where risks are creeping through our safety management system. The second part is recording and reporting. Under Section 24, incidents and accidents, as they are called, are incidents or accidents that fit the criteria in this section of the Act. The Department of Labor requires companies to record these on an Annexure 1 form and report them using the correct reporting forms. Now, these may vary depending on who you have registered your COID or compensation with. We'll learn more about the entire compensation in General Administrative Regulations 9, Annexure 1 document, as well as the Department of Labor, FEM, RMA, COID forms in this course, which is Conduct an Investigation into Workplace Safety, Health, and Environmental Incidents. But take note that records need to be kept for a period of at least 3 years. This is all based on the legislation found in the General Administrative Regulations Section 9 of the Occupational Health and Safety Act. Now, Section 24 states that certain incidents and accidents must be reported to the Department of Labor. These are incidents or accidents that arose from their work or even in connection with their work. So even if a person was not working with a power tool, but someone in the vicinity was, and the employee was injured by that power tool, it's still in connection with their work and thus needs to be reported. Where any person dies, becomes unconscious, suffers the loss of a limb or part of a limb, or is injured or becomes ill to such a degree that they are likely either to die or to suffer a permanent physical defect, or even if they are unable to work for a period of at least 14 days, these must all be reported. They generally are reported by the employer or the user of the machinery. Other incidents that must also be reported to the Department of Labor are a major incident, or where the health and safety of any person was endangered. This is an interesting one, because the person was not actually injured. In this case, their health or safety was endangered. That means there was a high possibility for the person to have been seriously injured. These also need to be reported, so that even potentially harmful incidents or accidents can be investigated and hopefully mitigated. Then, where a dangerous substance was spilled, the uncontrolled release of any substance under pressure took place, machinery or any part of machinery fractured or failed, resulting in flying, falling, or uncontrolled moving objects, and lastly, where machinery ran out of control. Now you may wonder, who must report these incidents or accidents to the Department of Labor? Well, they must be reported to an inspector by the employer or the user of the plant or machinery. So if you are an employee and were the user of the plant or machinery, you also have an obligation to ensure that the incident or accident is reported to the Department of Labor. When must these be reported? The above-mentioned incidents under Section 24A, B, and C should be reported immediately to the Provincial Director. It should be done by telephone, fax, or similar means of communication. They should also be reported to the Provincial Director within 7 days using the correct forms. If the injured person dies, the employer or user shall notify the Provincial Director of the death by fax or similar means of communication. The incident site may not be disturbed without the consent of an inspector in the case where a person dies, loses a limb or part of a limb, is likely either to die or be disabled. Action may be taken as is necessary to prevent a further incident, to remove the injured or dead, or to rescue persons from danger. However, this does not apply to traffic accidents on public roads, incidents at a private household, or accidents according to the Aviation Act. The investigation should be performed by one of the following persons: the employer or user of machinery, a person appointed by the employer to investigate the incident, the health and safety representative of the work area, a member of the Health and Safety Committee. The investigation should officially start within a period of 7 days and be finalized as soon as is reasonably practicable, or within the contracted period in the case of a contracted worker. An employer must ensure that the incident or record be examined by the Health and Safety Committee. A health and safety representative might also be called upon to assist with any subcontractor or mandatory, or even sit in when discussing acts or omissions by employees. Let us discuss what acts or omissions by employees or mandatories are in Section 37 of the OHS Act. Keep in mind that to do something means to actively do something with full knowledge of what you are doing. To omit to do something means to fail or neglect to do something that you are supposed to do. In the context of what we are discussing in Section 37, a mandatory is defined as an agent, a principal contractor, or a contractor for work or service provider appointed by the client to execute a scope of work on its behalf. Whenever an employee does or omits to do any act which it would be an offense in terms of this act for the employer or such employee or a user to do or omit to do, then unless it is provided that, in doing or omitting to do that act, the employee was acting without the connivance or permission of the employer or any such user, it was not under any condition or in any circumstance within the scope of the authority of the employee to do or omit to do an act, whether lawful or unlawful, of the character of the act or omission charged, and all reasonable steps were taken by the employer or any such user to prevent any act or omission of the kind in question, the employer or any such user himself shall be presumed to have done or omitted to do that act, and shall be liable to be convicted and sentenced in respect thereof. And the fact that he issued instructions forbidding any act or omission of the kind in question shall not in itself be accepted as sufficient proof that he took all reasonable steps to prevent the act or omission. The provisions of subsection 1 shall mutatis mutandis apply in the case of a mandatory of an employer or user, except if the parties have agreed in writing to the agreements and procedures between them to ensure compliance by the mandatory with the provisions of this Act. Whenever any employee or mandatory of any employer or user does or omits to do any act which it would be an offense in terms of this Act for the employer or any such user to do or omit to do, he shall be liable to be convicted and sentenced in respect thereof as if he were the employer or user. Whenever any employee or mandatory of the state commits or omits to do an act which would be an offense in terms of this Act, had he been the employee or mandatory of an employer other than the state, and had such employer committed or omitted to do that act, he shall be liable to be convicted and sentenced in respect thereof as if he were such an employer. Any employee or mandatory referred to in subsection 3 may be so convicted and sentenced in addition to the employer or user. Whenever the employee or mandatory of an employer is convicted of an offense consisting of a contravention of section 23, the court shall, when making an order under section 38(4), make such an order against the employer and not against such employee or mandatory. To do something means to actively do something with full knowledge of what you are doing. To omit to do something means to fail or neglect to do something that you are supposed to do. Let's give an example. You are asked to work in a group of persons on a site. You are friends, and you enjoy having fun with each other outside of work. Perhaps you even play sports together. So you know each other and you are very good friends. When you see one of your friends walking to the lunchroom, you decide to try and race them there, forcing them to join you in the act. While running to the lunchroom, your friend trips and falls to the ground, breaking his arm. Would you agree that this type of behavior is dangerous? Could it even have been worse? Yes, definitely. In fact, there are many case studies that show how dangerous horseplay can be, even fatal. This would be an example of doing something that is considered an offense, and you can be held liable or responsible for the outcome. Why? Because you know that it is dangerous, and also you are told on site that you should not engage in horseplay. Now let's look at something that a person could omit to do. You are working with a grinder, like the one we spoke about in section 15. You are required to ensure that a risk assessment of the area is done to ensure you adhere to any safe operating procedures while operating the grinder. But you decide that you are not going to do this time because it will take too long. While grinding, sparks settle on a couple of boxes that have equipment in that you are going to install. After a little while, the sparks start to form embers on the box and the box starts to burn. Then the box starts to create a flame and a fire starts to burn the boxes around you. A co-worker sees what is happening and quickly gets a fire extinguisher and puts the fire out. Fortunately, no one got injured, but the equipment is damaged and cannot be used. What do you think? Were you lucky, saying that it could have been worse? Yes, it could have been worse, but lucky is not a good way to work, because incidents and accidents can happen very quickly and can cause serious injury and death. Failing to perform a risk assessment meant that you failed to see the need to move the flammable materials out of the way and perhaps get a grinding screen to protect any other person who may have been in the area. Failing to do this is an offense, and you can be held liable or responsible for the outcome. Why? Because failing to follow safety procedures can lead to the loss of life. This is serious, and we would only want employees who take this seriously to work on any job. Note that under Section 37, if an employee does or doesn't do something that is in the interest of health and safety, then this offense can be held against them and their employer, unless it can be proven that the employee acted outside of their authority or without the permission of the employer. Now, what if the employer allowed it even though they did not know about it? What do we mean by this? When an employer has certain bad behaviors within the company and they continue to allow it without handling it in accordance with this act, then it could be understood that the employer is aware of these offenses but does not care about them. This type of negligence will lead both the employer and employee to be responsible for the offense caused. What are some bad behaviors? Could it be that safety is only a concern when a client asks for it? Or perhaps once the safety file documents are signed, work must be done no matter what, even if some safety rules need to be bent. When behaviors like this creep into a company, then the actions of employees will fall on the employer's responsibility. Verbal instructions must be backed up by proper procedures and training. The same can be true if a mandatory is working with your company. A mandatory is defined as an agent, a principal contractor, or a contractor for work or service provider appointed by the client to execute a scope of work on its behalf. What could this mean? If you needed to have scaffolding set up on site for you to perform works, the scaffolding company you hire to erect and inspect your scaffolding will be called your mandatory or contractor. If the scaffolding fails and causes a death, then both you as the employer and the scaffolding contractor will be held liable. The only way to minimize some liability would be to have an agreement between your company and the contracting company. This is usually called a mandatory 37.2 agreement. The purpose of this agreement is to establish at the start of any work that both parties are responsible for upholding the OHSS Act and its regulations. It is important that along with this agreement, the employer or client ensures that all legal requirements are covered by the mandatory contractor. How can you do this? Especially if you do not know their scope of work. Perhaps you do not know how to erect a scaffold or inspect it. How are you expected then to know this? Well, you do not need to know the how, but you are required to check that the agreement clearly outlines the duties of the mandatory and is signed by both parties. Since it is well known that contractors should have their own safety, all contractors and employers should develop a standard audit template of general safety requirements needed to perform all aspects of their work, including the works performed by their contractors. This way, they can appoint someone to audit the contractor and ensure that all legal documents needed to fulfill their work is available, sufficient, and complied with. This is also a legal requirement of anyone who appoints a mandatory within the construction regulations. If an employer does not know what to do, then they should get advice from a subject matter expert for the necessary guidance on compliance. It is very important that the employer take all reasonable steps to prevent any act or omissions by employees or mandatories. Because an offense would be breaking the law, it can be a civil or criminal offense, and thus the employee or mandatory can be convicted on the basis of this act. Whenever the employee or mandatory of an employee is convicted of an offense consisting of a contravention of Section 23, certain deductions prohibited, the court will make an order against the employer and not against such employee or mandatory. So remember, since we adhere to the OHSS Act for the protection of ourselves and others, we may harm or bring injury to others by what we do and also by what we do not do. The questions that may arise if an incident does happen is, was the employee acting without the permission of the employer? Was the act in the scope of authority for the employee? Could the employer have prevented such action? And is there a mandatory 37.2 agreement between the parties to establish compliance for the task at hand? Most employers are unaware that they can be held liable for the actions of their employees. Vicarious liability is where someone is held responsible for the actions or omissions of another person. In Neertling's Law of Delict, he describes liability as the strict liability of one person for the delict of another, which arises from a particular relationship between such a person. An example of this relationship is that of employment between employer and employee. Let us take a quick step back and have a look again at section 37.1, this time under item C. All reasonable steps were taken by the employer or any such user to prevent any act or omission of the kind in question. The employer or any such user himself shall be presumed to have done or omitted to do that act, and shall be liable to be convicted and sentenced in respect thereof. Now notice this very important section. And the fact that he issued instructions forbidding any act or omission of the kind in question shall not in itself be accepted as sufficient proof that he took all reasonable steps to prevent the act or omission. Note that under section 37, if an employee does or doesn't do something that is in the interest of health and safety, then this offense can be held against them and their employer, unless it can be proven that the employee acted outside of their authority or without the permission of the employer. But remember that just issuing an instruction is not in itself accepted as sufficient proof. All reasonable steps must be taken to prevent acts or omissions against health and safety.